initiate chaos theory guarantees that we'll play like lightning shots, sounding like thunder. For every time in the face that it hits us, we're faster. Well, they should know by now. They see the world keeps trying to shake us. It only wakes us. The pendulum swings. The pendulum swings. It's in a beautiful darkness. Only another. It's full steam ahead. Full steam ahead. All about the Betty Express. Misdirected from the start. It's a runaway train. I come a freight train. I come a freight train. In a beautiful darkness, the Betty Express. In a beautiful
I realize with terror that I have consigned us to watching this at normal speed. Had we stuck to the original 3 o'clock time, then we could have sped through whatever the defense craziness is going to be. But now we are going to be stuck with just current time. There are advantages and disadvantages to both. But right now, the inability to speed up Kim K is looking like a terrifying prospect. It's like, why don't I ever think things through? We are just waiting for court to come back, and he's been really punctual. I very much like this judge and his punctuality. It will be interesting to see what the state has decided after this longer period of time. And I do wonder, I know the jury isn't supposed to think about what is going on, but they have to be wondering what is going on? What are the lawyers fighting about? And depending on their individual perspectives of how the defense has been going, it'll if anyone ever talks on the jury, it will be interesting to see how they felt about both cases, the state and the defense. It will be interesting to see how they perceived it. Oh no, are they asking for another sidebar? Interesting. And really the only thing I haven't agreed with this judge about is the retention of the jury member who made a comment to the sheriff's or the bailiff or the deputy. Again, I think like the firefighter, it can be excused as a human thing and not an intentional, act to either contaminate the crime scene or anything. Like with the firefighter who found Sophia and brought her out before the decision was made to evacuate all of the victims' bodies. It was a human thing after that testimony last Wednesday. I can completely understand, but I think that to err on the side of caution, I would have, I would have done something to the effect that the Uvalde judge did with the one witness whose testimony was stricken. I would have basically, been very gracious and, try not to make the juror feel bad. But I would have let him go. That being said, this judge is much more familiar with the appellate laws, the appellate court, what is typically an issue in this locality versus what is not, what's a, reasonable error, what is not. So this is coming with my opinions are coming with a very limited knowledge of actual lawyerosity. Now, it is interesting that neither Kim K or Ponytail look that subdued. I mean, I think Kim K kind of knew that this was going to go against her from the beginning and had already kind of rebuilt her mental kind of fortress against reality. I have never seen two people so impervious to, reality and how things are actually going. It is interesting. And then I was just looking on, the Twitter to see if anything else has come out as far as new information in the Guthrie case. It just seems very odd. Oh, it looks like there's a video. Again, I haven't been keeping up, on that, so it is interesting. Come on, court. Oh, this is terrible. Why did I not remember that this is why I always wait a couple hours? Because I have the patience of youngest most feral. He comes by it honestly. He really does. I guess the other question is at the end of the day, beyond Katie, is there any other witness that the defense is going to call other than potentially Paul? I don't know. I with the way that this particular family member testimony has gone, would you wanna take the chance of bringing up another family member who, again, as it seems that you didn't do any sort of pretrial, uh, investigation on prior to several days before you put Katie on, I can't imagine that you would want to for the same reason the state doesn't appreciate, having this witness without any notice, that you Yeah, my son is still just, finds it hysterical that people watch trials all day. He's like, "That is weird." He's like, "Why don't you watch Roadblocks?" And I was like, "'Cause I find that weird." He's like, "People are all weird." And I was like, "Yeah, that's kind of the point." The wisdom of Mo. We're all weird in our own unique way. And Mr. Mo and middle child got back. He was very brave during his cavity filling. I swear, I yell at them every night. Put toothpaste on toothbrush. Run said toothbrush over teeth. Oh no, Major Mom. Prayers for our RV resorts maintenance guy. He was found down yesterday. Rumor is a stroke. Oh no, he's young with two preschool kiddos. Oh God. That breaks my heart. It's hopefully they found it quick enough, and with, modern medicine, there's more stuff that they can do. But that is now I will say that a lot of people feel helpless. If you want to help out the family at any um the little things that people always have to go out to groceries to get, toilet paper, paper plates, even plastic forks and dishes. When I lost my husband, my mom actually had the idea to take all that kind of stuff over to my in-laws, so they wouldn't have to go out to Walmart for, any fiddly stuff while maybe they just didn't feel like it, because this was before anyone had even thought about, Walmart delivery or things like that. And I think my in-laws really appreciated it. And it was it was something I've always admired in my mom, because I know that she was not the biggest fan of my first husband, and she would be the first to tell you that straight up. Uh, but when it came down to it, when people were hurting, she, went through, did an extra grocery run, and filled up 2 big bags of things to take over there, so they wouldn't have to go out, for the little fiddly stuff of life. The toilet paper, the paper towels, the paper plates, the forks, the knives, if they didn't feel like doing dishes. And it's just one of the more thoughtful things, that I've ever seen. So I always recommend, if you're not sure what to do, you don't know what would be helpful, those things are always helpful to me. Now, I want to say that this comes from the lens of I am an inside cat. Some people like to be extroverted. Going out takes them out of their mind. out of, sticking in their place of grief. So, play it by ear. But that's one of the things that I always thought was maybe not something everyone thinks about with like meal trains and like food trains and things like that. But, not having to run to Walmart to get toilet paper or things like that. It just always seemed like a really uniquely thoughtful thing for my mom to do. So it's kind of been my standard practice when anyone has kind of big stuff going on. Hey, I'm running to Walmart. Do you need me to pick you up anything? No, I don't expect payback. Just, do y'all need like paper plates, paper towels, you know, things like that? Just because you generally know people are going to get food, but it just, having paper plates and things that you don't even have to wash dishes with, it's a it's just a nice thing that I always thought. So I've kind of incorporated it into my kind of life wisdom plan, I guess. Okay, we are now 10 minutes behind. The judge and first best Gigi. Yeah. Well, and sometimes I don't know because I know that I I have no real I can imagine what it's like to be an extrovert, but I don't understand it. It fundamentally doesn't make sense to me. So I definitely can try to figure out what they would want or need. Yes. Yeah, and it's a different thing. I think there are some things that, oh, okay. Well, I'm glad that they have family there to surround them. But I'm glad that he was found and hopefully he's getting really good medical care and they're getting support. And I'm glad that they've got family because family knows how to support you most of the time, where maybe like your friends and other people might not have that experience with you. Now, sometimes it's completely the opposite, where your family doesn't get you at all and your found family does. So it swings and roundabouts. I've been Y'all, I have been over here stalking UK news to see if the prime minister is still there. I'm such a nerd. I really am. Oh, it does look like there have been at least some kind of Ring camera video released in the Guthrie case. I'm semi-tempted to look at it and not really because honestly, until it comes out in a court case, I have found that since I've kind of exclusively gone to watching trials, that watching true crime, again, there are some awesome true crime channels out there, Bailey Sarian and, that chapter. So it's not disrespectful in it's not meant to be disrespectful, but I have found it difficult to watch true crime channels when a lot of what they bring in is hearsay, which is interesting to speculate about, but isn't something that I can bring into the trial other than to say that there has been speculation.
Where we are.
Judge, I think we're ready to continue with the direct examination of Ms. Canerio.
Okay. Have we come to an agreement as to when we're going to deal with the stipulation issue?
I think before we leave for the day, we can give that to the court. I mean, I think it's like one sentence. One of us just has to write it out.
Okay. All right. Defense, anything else that we need to put on the record before I bring out the jury?
Not at this time.
Okay. You can ask the jury to come back now, please.
Y'all, I am just warning you, if we get one or two questions into the defense's direct, and we have another piece of evidence that this heifer has tried to use the same logic reasoning for not showing the state, I am going to lose my mind. I think we are going to see the judge flip his table. But I have a feeling it's coming up. I have a feeling she didn't learn not one GD thing, and she is going to try to bring up yet another issue that has already been taken care of in motions in limine. I foresee it. Is she Scottish now?
Good afternoon, everyone. You can be seated.
Good afternoon.
Thank you all for coming back this afternoon. As I indicated this morning, we had a legal issue. So if you want to have a doll, like a Markham U doll that you want to use to kind of stab at for being late, you can blame everything on me, on nobody else. Sometimes things take longer than expected, but we are ready to proceed at this point in time. So thank you very much for your patience, for coming back for the afternoon. We really do appreciate it. Thank you on behalf of everyone here. We're back on the record with State of New Jersey versus Paul Caneiro. It's indictment 19-02-0283. And have the appearances of counsel for the record.
Good afternoon, Your Honor. Assistant Prosecutor Nicole Wallace on behalf of the state.
Good afternoon, Judge Chris Decker for the state.
Good afternoon, Your Honor. Monica Castello on behalf of Mr. Paul Caneiro, who's present.
Good afternoon, Andy. Okay, good afternoon, everyone. Good afternoon, Mr. Caneiro. We'll continue on with the testimony of Caitlin Caneiro. If she can be brought back up, please.
But let's be real. If you have the perception at all of if you have the perceptive abilities of anyone with the IQ above room temperature, you are going to, even if you don't assume anything and you were to simply pay, I don't know, strategery, the likelihood of this being a defense mistake that had to be fixed is kind of, very apparent through deductive reasoning. But that being said, this is why I fundamentally would be a terrible juror, because I would probably know the reasoning for hey, I got through. I was very clear on what I did on the paper. I was like, I know more about trials than the average bear. Are you sure you want to have me? To be fair to both the prosecutor and the defense, I did have bright pink and purple hair at the time, so they were probably both assuming I was stupid.
Just watch your step, please, if you don't mind. I want to remind you, you're still under oath from yesterday, okay? We can continue on with the direct examination. Go ahead.
Tiny baby Jesus. I'm going to be unable to fast forward through the absolute weaponized stupidity that is the defense's direct on this woman. Now, despite whatever her behavior has been and my thoughts thereof, she is pregnant with a baby, and I do not want to be a total and complete cahoon to her. Please give me your strength and hold my tongue when I want to verbally eviscerate this woman, allegedly in Minecraft and all that stuff. Amen. All right, let's hope that this works. Y'all, I'm going to try.
Thank you. Good afternoon, Katie.
Good afternoon.
So, just a couple more topics I wanted to cover. One of them I wanted to circle back to was
No, for the love of the ghost of Jen Psaki and all the circle backs before, and the ghost of Christmas past. No, for the love of 12 and 13 and 17. Ma'am, you have never even started on a point. You are a roundabout of stupid. You start at stupid and end at stupid. There is no point in circling back, you stupid bitch. Well, I made it all of 10 seconds, but I didn't make fun of the pregnant woman.
I think you testified yesterday about the Porsche Macan.
Yeah.
And I think you mentioned it was a loaner vehicle.
Yes.
Approximately how long did your dad have the loaner vehicle for?
I'd say less than a week.
And why did he have a loaner vehicle?
His car was in the shop. I don't remember why.
And with respect to, we also heard a little bit about soundproofing in your house through some testimony. Was the master bedroom of the house soundproofed?
Yes.
And what about
Yes, because no one on this green earth needs to hear him and Susan make love. Ugh. Look, that's like the one kind thing that Paul ever did for humanity, was to make sure that no one else had to hear this crap. I mean, oh, good Lord.
the basement?
Yes.
Okay. And to your knowledge, who did the construction of who did the construction of the remodeling and including the soundproofing?
It was Corey's best friend, Tom Z.
And as the construction and the soundproofing was happening, was Corey ever there at any point?
Yeah, he would stop over and him and Tom Z would go get lunch together occasionally.
Counterpoint, you're letting someone with the name Tomsy do anything in your house. I'm guessing he doesn't have a contracting license. I'm guessing he's not bonded and insured. But it seems like the first mistake was letting someone named Bonzi work in a contractorial, proclivity at all for you. Now, I say that with the full knowledge that Mr. Mo, does have all the skills and is not, a quote unquote contractor. But I still have to say that, oh my, this is so, let's go.
Now, we've also heard testimony about a little bit about a backpack. Did your dad have a backpack?
Yeah.
And is that something that, did you see him carry it around?
Yeah, he carried it everywhere. It was almost like an extension of his wallet. Everywhere he went, the backpack went.
And for how
Was there always savings bonds and passports and different things like that? Also, Judge, come on. Well, he did have to do a lot of talking today. I'll allow it. We will not rapper shame the judge today. This man needs all the Ricolas.
How long would you say that your knowledge your dad had the backpack?
I don't know exactly, but at least since I've been in high school.
So
That time, around 10 years.
10 years. And just a couple questions about your dad. Can you tell us a little bit about your dad as a dad? Was he a good dad or?
Yeah.
Objection.
Stronger prayers, baby Jesus in heaven. Look, my face is going to say some things, but I'm going to try to keep my mouth shut. Amen.
It's irrelevant. It's irrelevant. Sustained.
How about your dad as a brother? How was his relationship with Keith?
It was very good. They were very close. They did everything together.
And what about your dad as an uncle? How was he with Jesse?
I mean, he treated them like he treated me and Marissa like his own kids, and he would drop everything for us. He'd always be there. He was very supportive. It was just good to have around.
Specifically about Jesse, what, if anything, can you tell us about their bond?
They had a great.
I'm putting this on the defense. I am putting this on the defense. Defense, you have been the worst example of a lawyer I have ever seen. And that does include Daryl Brooks and Lori Vallow being their own pro se, lawyerologists. You you have the honor. You got to go to school. You went and did this career. And I assumed at some point you had a motivation to seek justice. Again, it might not be, through my prism of seeing justice, but I assume because I try to give people at least motivations that are not malignant at first. What happened? I just, oh, this is so gross.
Great relationship. They had a lot of things in common. Jesse loved history. My dad loves history. So they would do a lot of things like that. When Jesse was learning how to swim at the Sultan Club, he asked my dad, who I tagged along with, and we watched his little race when he learned to swim. And then one time, I think Jesse was in preschool, he was able to bring a discussion.
The only comment I will say, because I am trying to be nice to the pregnant woman, is that when I think about certain memories of, and I'll go ahead and use my mother-in-law who just recently passed. There are some memories where I'll start out thinking I'm fine and I'm laughing, and towards the end, I don't realize that I'm crying too. And to be fair, I'm not very connected to my emotions all the time. So I find it hard that all of these witnesses can talk about memories of these children without choking up. Even if they, to the bottom of their heart, don't believe that Paul did it, it still chokes me up to think about last Wednesday, and I am in no way related. So it does strike me as very, very odd to me. Now, again, everyone grieves differently. This has been 6 years. So, but I would think with the compounding trauma of having seen what they saw on last Wednesday, it would be very difficult to speak about these children in this tone. Now, I have seen her in the background of the court, so it's just, again, having grieved very close losses in my life, there is something about this that doesn't ring quite authentic. Again, I'm not saying I'm a professional, but there's something a bit off about it. And that's all I will say, because I can't imagine having to admit to yourself that your father might have done this. So I am trying to give her more grace than I was going to give her yesterday. But I do find it a little odd and off-putting the way she can just talk about this now. And I don't mean that you should always have to perform grief. You don't always have to cry or something, but I would think with the proximity of what they saw last Wednesday, it would hit a bit different. I know it would hit differently for me, and maybe that's my blind spot here, that I don't understand how it couldn't hit you.
Her friend to show off to his class, and he invited my dad.
Did your dad and Jesse ever do things together, like lunch or anything like
Yeah, they
that?
did a lot together. When Jesse was bored at home, he would call my dad to hang out, and either Jesse would get dropped off or my dad would go there. But they did a lot together.
That's all I have. Thank you.
Cross?
Ms. Caneiro, it sounds like the children, Jesse and Sophia, would have trusted your dad, right?
Yes.
Now, do you recall?
Now, again, I kind of predicted that it was going to be the female attorney that was going to be on cross for this particular witness. Again, in the kind of, this is very much a male thought, because if you talk to any woman, they would tell you, let the man cross-examine her, because men typically are not as argumentative with women. They tend to back off if a woman becomes emotional, even more so when she's pregnant. Now, another woman will gut your soul no matter what. So I do question the entire red outfit. as far as I think that the female state's prosecutor was picked to appear more gentle in the cross. But this woman, that's like going to Nurse Ratchet and expecting compassion. This is the wrong. Well, on the surface, if you're a very surface level thinker, this makes perfect sense. If you have at all been a woman surrounded by other women, you know that there is no one more vicious than another woman. And you are like, oh crap, this is going to get interesting. And you're like me, and I'm like, oh, subtle petty incoming. Yes.
Yesterday, there was some testimony where you had sent your Aunt Jen a text message on November 20th in the morning of 2018.
Yes,
Okay. And I think you said you sent the text message at about 10:26 a.m.
yes,
And your phone number ended in, it was 7924, is that correct?
yes.
I'm just gonna approach you with D154, which you've seen yesterday. And I believe that was what was shown to you yesterday, is that right?
Yes.
Okay. Now, this message, it's actually on the back page of it. The green bubble here where it says, the text message to her, where are you?
Yes.
Does it show as being read on here?
No,
Just delivered, right?
just delivered.
Okay. And then I think you said you looked at it later and eventually you saw that it was read.
Yes.
Now, does this appear to be a group text message? Let me ask you this. Do you see these numbers here right before it?
I like her hair. So I realized yesterday, in as much as there are very few the reference is going to sound terrible, but he kind of has a point. In reference to Hannibal Lecter, one of the worst things you can do in and around me is be disrespectful. I can forgive a lot of things, but the compounded disrespect by the defense really pissed me off yesterday, and I was not able to give as much grace to this witness as I probably could. So I did speed through a lot of her direct yesterday because I didn't want to be a total butt monkey. I'm completely okay with watching calling a spade and a strike, but my general rule of thumb has always been to avoid family members. And while she insert herself into this trial, I also was able to look more realistically at the very, very difficult psychological, reckoning that would come with accepting the reality that the state has put into evidence. So I do understand, and I think it's a cute hairstyle. So I'm trying to be nicer to her, even though she has tested the ever living bit of my patience. I can't imagine having to deal with the truth that my father most likely did this.
First number?
Yes.
Is that your number?
Yes.
And that ends in the 7924 number, is that correct?
Yes.
And then you have Aunt Jen's number here.
Yes.
And then this 848 number, do you see that number?
Mhm.
Do you recognize that?
No,
Is that a number associated with EcoStar?
I have no idea.
You don't know. It was in your group text message though, right?
There was no group text message with my aunt.
Okay, well then what is this?
I don't know.
Objection?
We talked about.
Oral.
Okay, let me show you. I'll show you something else. Miss Caneiro, did you have another phone number at the time or another number that was associated with your phone?
Whenever I traveled to Greece, I had a different SIM card.
Did you have a different phone number?
It was a different SIM card, so yes.
So he has a different phone.
Did she add herself to the group thing with her Greek SIM card? Dear God, ma'am, I am trying my nicest to be kind to you because you carry life within you, but good Lord, if this is going where I think it's going, God bless your heart. Just, I am trying to be nice and you are testing my niceness. Stop it.
Yes.
Yes, okay. And that other phone number, was that 732-268? No?
No, it was a Greek number.
Okay. I'm gonna show you what has been marked, and I'll show council as S504. First page of the extraction report. First page of the extraction report. May I approach?
You can.
Okay, I'm gonna show you what has been marked as S504. This is the first page of your extraction report from your cell phone. And let me just ask you, you recall that your cell phone was extracted back in 2018, right?
Yes.
Okay. I'm just going to show you you recognize this number here. This 7924 number. Do you recognize that?
Mm-hmm.
Okay. Is that your number?
Yes.
And that's the number you texted Aunt Jen from, right?
Yes.
And then this number here that ends in 8977. Oh, wait a second, I'm sorry. It's actually 9357 right there. Do you see that?
Yes.
Okay. That's on the extraction report. Do you recognize that phone number?
No.
You don't recognize that? Okay. I'm showing approaching with S505. If we could take a look, I'm going to show you first the 154. This is your text message, right, to your Aunt Jen on 11/20/18?
Mm-hmm.
Okay. And I'm going
You
to
have
show
to
you.
say yes or no.
Yes.
I'm going to show you what's been marked as S505. Do you recognize that same text message on here?
Yes.
Okay. And does that appear to be part of a group text message?
No.
It doesn't?
It's not a group text. It's a conversation between me and my aunt
Okay.
from the previous day.
But do you see the numbers up here where it says Aunt Jen and then it has the 848 number and the other number that is marked 357? Do you see that?
I see it, yes.
Okay. Does that appear to be a group text message?
I don't know. I don't see any other text messages.
Oh my God. Yes, it's a group text message. Yes, you know what is a group text message because you've got like the comma and every other 900. And then my family gets into a meme war and I can't sleep because people are sending texts in different time zone. Good night, nurse.
If you look at my phone, it is a conversation between me and my Aunt Jen.
Oh, sweetie, the state has all the evidence. They extracted your phone, and you can go ahead and say, that's not a group text, but I'm going to guess that they have the extractions of the other phones that were associated with this group text. So however you want to approve, not approve, whatever group text this was, the state has what we like to call recipients or receipts, depending on how dyslexic you are.
Caneiro, I'm going to ask you a couple of questions just to clarify some of the cars that you guys owned. So you indicated your dad owned or drove a white Porsche Macan, is that right?
Yeah, this was a turbo.
Okay, and I think you said his car was actually in for service, so he had a loaner car.
Mm-hmm.
And the loaner car that he had on 11/20/18, that was also a white Porsche Macan, is that correct?
Yes.
Okay, and it had like the black strip on the bottom doors.
I'm sorry?
I don't remember.
You don't remember? Your mom's car, the car that she drove was a Porsche Cayenne, is that correct?
Yes.
Is that the car she routinely drove?
Yes.
And that's the car your dad pulled out of the garage, is that right?
Yes.
Now, did that car have a remote garage door opener in it?
Yes.
It did, okay. You had an alarm system in your house, isn't that correct?
Yes.
And did you have multiple cameras in your house?
Yes.
So you had an alarm system. Did you also have a DVR system that was separate?
I don't know how it works, but
Okay, so you had an alarm, no system that was hooked up to your house?
it was, but it never works. So
Okay. Certain doors like would beep when you were in
Yes.
and out?
Wait a minute. Paul set up every other friend of his guy that he took to his maybe Fabian Society barbecues. I don't know. Anywho, he managed to set up working security systems for everyone else, but not his house. What a coinky dink. Interessante, if you will. It's almost like that doesn't make one gosh darn lick of sense.
And then some doors didn't beat, right?
Yes.
When you're coming out. All right, so you had that, and then you had some cameras inside your house, is that right?
I know that now. I didn't know that back then.
You also had cameras outside your
Outside,
house,
I
is that
know that.
correct? And then you had like a DVR box that was located in the garage, right?
Yes.
All right, so I would imagine at night you kept your doors locked, is that right? Yes. Now, the doors that would beep when you would go in and out, that would be the front door, is that correct?
Front door, yes.
And then the garage doors?
Both of them, yes.
And was there another one?
Yeah, the back door in the laundry room.
Back door. Now, the French doors and the sliders, they would not beep, right?
No.
If you're coming
This is what happens when you give a competent, very smart attorney 15 minutes to prepare. This woman is going to destroy this woman with, oh, so you didn't hit an alarm? So Corey was able to come into your house when it was locked. Did you have spare keys? Oh, interesting. Did Corey say anything like, screw you, Paul? Or anything? This is going to be so fun. I am so excited.
out. And where were those doors located?
The slider doors were in my kitchen and the French doors were in the dining room.
Okay, and did they lead right out to the backyard?
To my deck,
To the deck.
which was in the backyard, yes.
Now, you indicated that your dad's room was the guest room, is that correct? And was that room, if you go up the stairs, would it be all the way to the left?
Yes,
And then next to his room was your room, right?
yes,
And then next to your room was your sister's room?
yes.
Marissa's room? And then was there a bathroom after that?
And I think that's why the state's attorney is being very strategic. She's getting her into a pattern that she's just asking very innocuous questions. And she is really she's not lulling her, because Katie seems to be very on guard for that. But what she doesn't realize is that by talking about these very mundane things, it just stretches that credulity that Corey Caneiro would be able to go into a house, leave nothing of himself behind, and then, have done this amazing conspiracy without any evidence of it coming out in 6 years. 6 years, no one's talked. Corey hasn't bragged and said, I framed the shit out of my brother. Nothing, not a single whisper other than from the defense has come up to say, Corey done it. I heard it. No.
And then the master bedroom, right?
Yes,
Okay. And the master bedroom, that was the side that was closest to the fire, right?
one part of the master bedroom. I mean, it wasn't the bedroom, it was the closet and the bathroom.
So it like shared a wall with essentially where the fire was?
The fire started in the basement and it went up the back of my house, which was the master bathroom and the master bedroom, not the bedroom, master closet, not the bedroom.
Okay, so the master,
This is weirdly detached language. Again, she's had several years to process this, but most people would okay, it's going to sound preposterous and like it doesn't, but there was a time when we had first moved into this house that youngest most feral decided to sleep in a cabinet, as you do. And, my brain immediately went to the drop off that we have at the back of our property and then the pond that we have across the street, because my ferals were really good at opening the door and we hadn't gotten time to put those hotel chain locks very, very high. So they couldn't, open doors. Now, I am not a runner, but I think I ran around my entire neighborhood in about 10 minutes and called the cops. And of course, as soon as the deputy arrived, my youngest most feral comes up like, Mommy, I was tired. And I told the deputy, you could want to stay here for a moment because I don't know whether I want to hug or yell at this child to it. I was like, you are cute for your safety. Now, that being said, even though right now I know that everything turned out okay, I can tell you the absolute terror that I was feeling, and I can go back to that and tell you that that was probably one of the most terrifying times because with every step I was taking, I was like, "Oh my god, am I gonna find him here, lying here? Where did he go?" That's the kind of thing that runs through your head, and while it might not be a child, it's your mom, so I would think that you would still be thinking again, while 2 things can be true at the same time, you cannot, alternately say that you were so traumatized on the day of the incident that it was against your human rights to have to give a statement, and then show really no give a damn that the room that your mom potentially was in was more significantly burned. It it really does undercut one argument undercuts the other, and while 2 things can be true at the same time, it really undercuts this optical, this narrative that you're trying to build. It really undercuts it when you are blasé and glib about the potential trauma that, anything could have gone wrong. That's usually where people's, kind of living anxiety from these old things happen is that we realize that in another universe, in another timeline, things could have gone terribly wrong. And that usually keeps us up at night more than the actual incident.
Your bedroom closet was where the
Yes.
fire started, right?
No, it ended in the closet.
Okay, but it was on that side of the house. You
Yes.
understand what I'm saying?
Yes.
Okay.
The bedroom went all the way across.
Understood. It wasn't closest to your dad's room, right?
No, it was closest to the master and my.
I'm sure the people on the Titanic were like, the iceberg was only near the front. So I was like, F you, I'm in the back, I'll be fine. No, it is this equivocation that really, if I could give anyone advice being a witness, don't argue over stupid shit like this. This undermines your credibility as a witness. If I see a witness doing this, whether I'm watching a trial or, actually in the courtroom, regardless of what side they're on, this if you are not willing to concede to obvious points, it is absolutely ridiculous. I don't get it. I don't understand it. It just makes you seem unwilling to accept a truth and willing to shade your testimony to fit your own narrative.
My sister's side of the house.
Now, your mom, you guys had some Australian sheepdogs, is that right?
Yes.
2 of them?
Yes.
Okay. And I think you indicated, or you may have been indicated that they were with your mom in bed?
That's where they slept in.
Did you ever hear them barking in the night?
No.
Now, on 11/19 of 2018, you worked all day,
Yes.
and then you got home at, I think you said at about 6:15, correct me if I'm wrong.
I don't remember the exact time, but 5, 6, yes.
Okay.
That sounds normal.
Were you the last one to go to bed that night?
Yes.
Okay, your sister and your mom went to bed before you, is that correct?
Yes.
And you went up to bed at about 11:30?
Yes.
Now, when you came home, your dad was already up in his bedroom in the guest room, is that correct?
Yes.
Okay, and you did not see him the rest of the night, is that right? Okay. I know you indicated, I think, on direct examination that he was sleeping.
Yes.
Okay. You didn't see him though, so you can't say what he was doing, is that correct?
No, I didn't go in his room.
Now, obviously, you wouldn't be able to see anything or hear anything that he may or may not have done when you were sleeping, is that correct?
What? Sorry.
You were not able to see your dad, anything he may have been doing in the middle of the night while you were sleeping, is that correct? And he was the first.
Well, it does seem like a really silly question. They do actually have to lay the foundation. It is kind of one of those pedantic things, but you do have to get the witness to admit that, yeah, when I'm sleeping, I'm not going to be able to monitor my father. Again, she's the type of witness that I'm actually shocked that she agreed. But sometimes you do have to lay down these very, gravity is a thing questions.
Person you saw the next morning, is that right?
Yes.
He was the one that woke you up?
Yes.
Yeah, so obviously he was already awake before you were awake, is that correct?
I took sleeping pills the night before, so I did not hear the fire alarm.
But he was awake prior to you being awake, is that correct?
Yes, I was the last one awake.
Now, you mentioned on direct examination that your dad kept some of his guns in the unfinished part of the basement. Is that right?
Yes,
Is there like a metal locker down there?
I don't know what it looked like. Like, I know the area, like I would be able to recognize as my basement, but I don't know exactly.
Okay, but his guns were kept, you said, in the basement?
In a loft area, I guess.
And also there was a safe in the garage too, is that
Yes.
right? Okay. But that wasn't the only place that your dad had his guns, was it?
To my knowledge, it was.
You weren't aware of a Sig Sauer gun that was located in the guest bedroom with a laser light in it?
I don't know what a 6 hour is.
Do you know what a laser light is?
It's a laser, that's a light.
Do you know what it is or no?
No,
Okay. You don't know what it's used for?
no.
Now, your dad was good with IT and tech related things, is that correct?
This is what he did for a living, so yes.
And he installed the cameras in your home?
Okay, Miss Snarky Retard, let me explain why she's asking that question. Because you sat there on direct and said that the security systems never worked. So she's pointing out the utter ridiculousness of this scenario. Now, maybe, yeah, it's just like they're on the fritz. There is a reason she's asking this. I know you're not used to lawyers that actually typically know the answers before they ask you a question because you've only been introduced to Kim K. But this is what a real lawyer looks like. She knows the answer before you give it, and she's going to make you look fucking stupid. Sorry, I do not deal with attitude. I do not deal with attitude that cannot see that they're walking into a trap, but I do love it.
Installed, I wasn't there for it. I have no idea.
Did he set the cameras up in your home?
He used the cameras.
Okay, and would he maintain the cameras?
Yes,
He would be the one to handle anything camera related?
yes.
Okay. Do you know that he also installed, and you may know because you were sitting here, Dr. Gold's cameras?
I know that now.
You know that now? Okay. If anyone in the home would know where the DVR was located, the box, it would be your dad, right?
We all knew.
Including your dad, right?
Yes.
He was the one that maintained the cameras, correct?
Yes.
She's asking you this because she's going to now be showing you body cam footage where Paul claims to not know where a DVR. He's like, we have a DVR. Oh my God. Well, let me think about that. I heard tell that we bought that, but the wife, she spends all my money. Yeah. Again, this is why you don't tangle with a multi-level thinker, ma'am. We have already strategized 12 steps in front of you to make you look like a dumbass. We did try to give you the benefit of the doubt, but you decided to tangle.
Do you remember an officer approaching you and your father on the morning of 11/20 and asking your dad where the DVR system was located?
I don't remember, but I saw it here. I was here.
It's not here.
Yeah.
You don't remember that, but you remember your dad saying, "Oh fuck, I hurt my hand." Just
Yes.
to be clear. Okay. Let's play, if we could, you have permission to play S78, which is the DVR of that portion of it.
Oh, the downfall of stupid. Now, the interesting thing is that this is actually the one who jumped in and spoke for her father, explaining exactly where the DVR was. Interesting.
Okay. Ms. Caneiro, I'm going to ask you just to watch this, and I might pause it and ask you a couple of questions. You can begin. Can we just have the court volume up, please? Pause it, please. Do you recognize the individuals on the screen or any of them?
Yes, my dad and my mom.
Okay. And whose car is that in the back?
My mom's.
The white Porsche Cayenne?
Yes.
Okay.
God, my ears.
It's your house? Yes. Where is that?
It's me, not my mom.
All the DVD stuff for the cameras and everything in the house. It's in the garage. In the garage? Yeah. Where in the garage?
I just want to be clear. Did you see when the officer asked you where all of the cameras were located? Did you see that part?
Yes.
and your dad looked at you and you said the garage. Did you see that part?
Yes.
Okay, go ahead.
You walk in the garage and it's all the way up top to the left.
And then the officer asked specifically where in the garage, correct?
Yes.
And your dad looked to you and said,
He was talking to both of us.
Okay, my question was your dad looked at you and said, is that correct?
Yes.
Okay, and then you told the officer specifically where the cameras were located, is that right?
Yes.
Okay, go ahead.
Do you have it running right now?
I've been having problems with stuff in the garage.
You've been having problems with stuff in the garage?
Yeah.
Okay.
I've been picking up an accident with all the companies.
Okay.
Now, did you hear your dad at that point say that he had been having problems with stuff in the garage
Yes.
and that he had a ticket open with one of the companies?
Yes.
You had no idea what that meant, is that correct?
No.
Yes or no?
I said no.
It's not correct.
No, I don't. I had no idea.
You didn't know what he was talking
No.
about? Because according to you, prior to you going to sleep that night, the cameras appeared to be in working order, is that correct?
I didn't check, but I would assume so.
Okay. And do you recall saying that in your statement that you gave to the police?
Yes.
That the cameras appear to be in working order prior to you going to sleep?
Yes.
Can I just see D1, 425 to 430, please?
Why
D1,
in the
425 to 430.
defense? What the hell were you thinking? Oh, she can't even find her own exhibits. For the love of Cheetos. Oh my God, don't. What the hell did you do to yourself? Oh, for the love of God. Taking women's suffrage back 3,700 years. Honest to God, serious legal question. Is there a mercy kill trial rule? Is there like a Patriots Seahawks kind of thing where we can just end a trial like y'all, like we can put the jury out of its misery, because I'm feeling like we've reached this point 17 times already in this trial.
I'm approaching with what has been marked as D425 first. You were shown this picture the other day, is that right?
Yes.
Okay, and that's a picture of your mom, your dad, and Jesse and Sophia, is that right?
Yes.
And about how old are they here?
I would say 4, 2.
Two and 4? I'm going to show you what's been marked as D426. Do you recognize that?
Yes.
And who is that?
Jesse and my dad.
And how about how old is Jesse there?
3.
3. Showing you what's been marked as D427. Is that your dad and Sophia?
Yes.
How old is Sophia about there?
2.
Showing you what has been marked as D428. Do you recognize?
You idiot giblet head defense. You decided to go with archival photos of them in toddlerhood and not recent photos. You are absolutely the most art-hearted people I have ever seen, beyond chia pet growers. And I want a chia pet, so I don't know why I just defamed chia pet. Pet rock owners. Y'all should have started out with a Tamagotchi. And if that lived, we'll let you deal with a Furby.
Is that one?
Yes.
That's your dad and Sophia, right?
Yes.
I actually very much like the way that the state is able to bring out different things. So as much as the defense is insufferable, I like how the state is being very methodical and getting things out of her that she doesn't realize are detrimental to her father's case. The problem is that Katie thought, again, that she was smarter than the state's attorney. So she doesn't realize that even with the innocuous questions of, well, did your father work with technology? And even though she thinks she's being flippant with the, cameras, there are things that are coming out that are detrimental to her father's case that I think she's not aware of, because they aren't because of their kind of banality, she isn't seeing them and how they work together as a tapestry. She's taking them very much, did your dad work in IT? Yes. Okay, well, he set up other people's security systems. Good boy. Uh, so he would be the one that would have set up your system. Yeah. And then when she goes in for the kill, like, well, then why did your dad pretend he didn't know where the system was? She doesn't realize that she was led this way intentionally because she's not used to people that are very strategic in their thought pattern and in their questioning. So and that's the thing, most people aren't. Most people, and I'm not making fun of Katie but most people do not go through this very extensive Socratic method for most things, or at least this questioning method, for most things. They don't look at it and analyze things like that. So it's not a skill that everyone has. So I'm not, questioning her intelligence, but there is something to be said about the wisdom of admitting that maybe you aren't the smartest person in the room, which I don't think she has yet, and her arrogance is going to cost her and probably her father.
How old is she there about?
3.
3. Showing you what's been marked as D429. Do you recognize that?
Yes.
What is that?
Jesse and my dad.
Okay, and about how old is he there?
5.
5. Okay, and then I'm showing you finally what's been marked as D430. Do you recognize that?
Yeah.
And is that Jesse and your dad?
Yes.
And about how old is Jesse there?
5.
When Jesse passed away, he was 11, right?
Yes.
And Sophia was 8?
Yes.
Okay. So of the photos that you chose to sample for your dad's special bond with the kids, they were older photos, is that correct?
I mean, yes, because that's all we have.
Older
All I
photos?
have. Yeah.
You indicated that your dad and your Uncle Keith were close, is that correct?
Yes.
Are you aware that they were so close that your dad was actually the trustee for your Uncle Keith's life insurance trust?
Yes.
You're aware of that?
I'm aware of that.
You were aware that they spoke daily, I believe you said too, right?
Yes.
Okay.
Now, this is the danger. I do understand why the defense brought her in, because she is theoretically safer than getting Paul on the stand to tell his side. Now, the problem is that for cross, if you do take this gamble, if you do take, a family member or the defendant up, they can get crossed. And Heather May, Mo in the deep end. So defendant's daughter is not defending her father very much. She sure seems rather disinterested, or is that? I think she is. If this is a front, this is a very good front. So I'm going to give her the possibility, but I think she is very, very sure of her own point, very sure of being very smart, and she's being disrespectful to the state. She's basically not even humoring them with her attention. And while that, strategy might work if you're having a fight with a very emotional person, that kind of trips them up when you're not giving or feeding into an emotional argument. It's not going to work in a courtroom. Showing, being very kind of stoic, not becoming angry or upset and just treating it like it's a bit of a joke isn't the vibe that you want to give if you are trying to be seen as a sincere witness. So I don't know if this is a defense mechanism she has to appear uninterested in things that are very important to her, to kind of disassociate from the emotional and, possible real complications and consequences of what happens at the end of this trial. Or maybe she's been told, hey, you're going to be under a lot of stress, try to keep things calm. I don't know. It's just not, I can't place my finger on it, but again, it just reads as very off. It reads as a very off priority to make sure that, you know, your father's honor is protected or that people have a good impression of your father, when I would think that chief among things would be to get justice for your family members as well. Because if you legitimately think the state screwed up the investigation, I would be right there. If you legitimately think that the state has done a crappy job, then you would be up there and you would be throwing sass. You would say, well, why didn't you investigate? I mean, because I could even see that being, you know, her being snarky if she legitimately thinks that her dad got stitched up. But what's coming across is arrogant and tragically unaware of maybe the reality that has been proven in this case, and she thinks she can charm and glib her way out of this. Now, maybe the defense has sold her a different story, and again, I can't imagine the psychological impact of having to accept what has been pretty much proven in court and through forensic evidence. I can't imagine having to know that my father and this monster were the same person and grieve the father I knew and thought I had and deal with this reality. So if she can't do that right now, I get it, but it's not a good look and it's not helping her case. And I think the defense was extremely arrogant and full of hubris when they brought her on. And again, I think it's incredibly callous to attempt to play on our heartstrings by bringing up Paul's very visibly pregnant daughter to try to soften him. It's just, again, I realize that she is probably not the type of personality that I would ever get along with. So I'm trying not to be super irritated with her because she just fundamentally has different life goals that I read as entitlement and disrespect, but it could be honestly not those things and simply a different set of values she lives her life by. So I'm trying not to be a total, see you next Tuesday to this woman, but every time I give her grace, it is like, and we'll just act like a heifer.
Were you aware that your Uncle Keith actually called your house line on the night of November 19th of 2020?
I was at work, so no.
So you were not aware of that? Were you aware that your Uncle Keith actually spoke to your mom once that night?
I know now, but no, I was not aware that day.
When your dad told you about the 4 text messages that Uncle Keith sent him in the middle of the night, he didn't tell you about those 2 phone calls?
No.
And by the way, the 4 text messages, when did your dad tell you about that?
That morning,
About when?
9:30 or 10.
Your mom, she did not work outside of the home, is that correct?
Sorry, no.
Do you recall her ever working outside of the home since you were born?
Yes.
You do, okay. About how long did she not work outside of the home for?
Probably since I was in first grade until after this.
Okay. And your dad was the one who paid the bills, is that right?
I have no idea.
Okay, you're not sure?
No.
Just speak.
Again, it's answers to questions like this. Yes, as a child, you probably didn't know. But logic dictates that if your mom didn't work outside the house, then your father someone was bringing in money. They don't give out houses for free. These are the kind of answers that bother me.
Speaking of bills, you guys had, there were 2 Porsches that we heard about that your parents each drove, is that right? And then what kind of car did you drive?
I drove a Porsche Carrera S,
Okay. And how about your sister?
Jeep Wrangler.
Okay. Did any of your family members drive an Audi?
No.
No?
Oh, wait, Keith.
This is a subtle bitchy move because she's definitely bringing up the father's friend with condo benefits. Yeah. Well, and here's the other thing, Gigi. Again, if you're a deep noticer, if my daughter was pregnant, I don't care if it would save me from anything. If I would not let, uh I would not let my daughter put my future grandchild in danger and, place her in, the position that she's going to have to get cross-examined. Also, we salute you, Lady State Prosecutor, for subtly bringing up the fact that Paul was screwing another chick.
I had it out at one time. I don't remember if he had it then, but
2018.
okay, no.
Did your dad pay for Keith's Audi?
I have no idea.
Now, you testified on direct examination that when you were about halfway down the stairs, you remember a loud bang, right? And yes. And then your dad saying, quote, "Oh fuck." Do I have that quote right? Or "Oh fuck my hand." Is that right? Okay. When in the last 7.5 years did you remember that little tidbit?
The whole time.
Because you didn't seem to remember it when you gave your statement.
Basically, the state took over the lunch hour and kind of went over information, and they are crossing the ever-living hell out of the defendant's daughter, and she is not looking good. I think so the defendant's daughter is doing a good job maintaining her composure, but it's so blasé, it's so glib, it's so kind of, I could be doing Sudoku in the DMV. It's very odd. It is very, very odd the way she's testifying. And you would think that with all that's come out, it might put a little bit more emotional toll on you to talk about your niece and nephew, especially with the autopsy information. She really, really seems like she couldn't care less. No, he didn't, because he did believe that there were certain things that basically the state could either get a continuance and do a further investigation into where the lap or the iPad was, or they could just strike that. So all of that information will be stricken. But basically, he's given the state very wide latitude to go a lot of places and cross that weren't really covered in direct. So he's basically given the state a good bit of latitude. And again, this undermines her story, with the basic premise being that you have had this additional information, you have had this possible information that could exonerate your father, but because you are so pissed off that they didn't treat you nice at the police station, you kept it for 7 years nearly and let your dad stay in jail. You had, this GPS information, this text message information. Yeah. And then in a 2-parent household, when mom's at home and there's food on the table and bills getting paid, dad must be working. Yeah. So I will say that the judge's reasoning was very well thought out, and I think the state is doing very good crossing her. And I think again, she is just giving off a very weird vibe. I'm trying to be nicer to the pregnant lady, but she's testing my ability to deal with stupid and petulant.
Back on the date that it actually happened. Right, it's not in your statement?
It's not in my statement, no, because I was asking to leave and they kept telling me that my cousins were okay and they would take me after my statement, so I wanted to get through it.
But 7.5 later, you come in here and you remember it today.
Why would I forget that?
Kind of like 7.5 years later, you decided to check the status of your Aunt Jen's text message, right?
Yes.
What prompted you to do that, by the way?
Because we were talking about her.
You hadn't checked it from the time you sent it, though, correct?
No, since that day.
Okay. And then I think you said you checked it a couple of days ago, right?
Yes.
So a couple of days before you were coming in to testify on behalf of your dad, right?
Yes.
With regard to your dad's hand injury, you didn't actually see him get the injury, is that correct?
I didn't see him hit his hand, no. I heard
You weren't
it.
even sure which hand it was, is that right?
No.
Just the last couple of questions, Ms. Canerio. You were obviously close with your Uncle Keith, is that right? and your Aunt Jen,
Mhm.
and your cousins Jackie and Sophia.
Yes.
And you're close with your dad, is that right?
Yes.
You guys have always had a close relationship,
Yes.
and you've maintained that relationship throughout the years, is that correct?
Yes.
And you're here today testifying on your dad's behalf, is that correct?
Yes.
You don't want to see anything bad happen to him, right?
What's worse?
You don't want to lose him too, is that correct?
It's already been gone. There'd be nothing that would change.
She is. The defense, I can understand what they were trying to do. And if she had been given a better coaching, I think that she could have become a more sympathetic witness. I think that she wasn't prepared. I don't think she understands. I think she understands what's at stake, but she doesn't understand that as a totality, everything is going to be judged by about her. And you almost need someone semi-tismy like me to watch her and give her feedback as how she's coming across to people, because there is something off-putting, and most people will just put it down to she's snotty or maybe she's dealing with trauma, but it is going to be incredibly noticeable that she didn't really get upset. Again, with all the testimony that has just come out, the recent very heart-wrenching testimony, it doesn't faze her, and it's very odd and off-putting. So these answers, while they might be very true, are very damaging.
Any redirect?
Just can you approach?
Oh, for God's sake. It also, again, it's so infuriating that this family continues to wear this like cape of victimhood when there was an entire family slaughtered. It's such an apples and oranges thing. Yeah, also maybe the jury doesn't want to see you yawning. Look, I'm not going to fault her for the yawning because as soon as I said it, I remembered how incredibly exhausted I was when I was pregnant. So I am trying to be at least give grace where I can. Now, would I maybe cover it? Would I cover my mouth? Yes, because I perceive things a little bit better, and perceive that it might look badly, regardless of however tired you are and pregnant you are, to yawn at a quadruple murder trial. Oh my God, Rain Man, could you not make that face? Now, the two MVPs, the real MVPs of this trial, have been these two interns. They have been the state's go-to Gals Tuesday. Every single exhibit, every single document, every single report that have been coming in for the state, and even some of the defenses, they have been, on the spot, ready to go. They have it going. They even correct and maintain, all the labels and the sub labels. So they have really, if we want to credit any two people for really keeping this trial on track, these two have been just 12 shades of awesome. And that's the thing, Granny Smith, while I'm willing to concede that there might be a possibility that she's disassociated because she is very, very intensely conflicted by this, I do wonder, again, that's not going to be what people will see at first. Most people are going to see this as you couldn't be less interested. And unfortunately, you're going to be it's the common denominator that wins. If more people are going to see a yawn as disrespectful, you could cover your mouth. I think we would all have grace for a pregnant woman, but I think with her, combined with her attitude and the fact that she's kept this important information, again, if you truly and completely believe that the state is doing a disservice, then please, by all means, would you carry a grudge against the state, or would you want to get this solved? I I don't understand. Now, I think she's consciously not looking at her father, because her last question was an implication that she would basically say anything to protect her father.
Whenever you're ready.
Just a few follow-up questions. Starting with the text message with your Aunt Jennifer, do you still have that text message in your phone?
Yes.
As you sit here today?
Yes.
And earlier today, did you have an opportunity to show it to the prosecutors?
Yes.
Okay. And from what you can tell on your phone, is it a group message or not?
It's not a group message, and if it was, you wouldn't be able to see that it's red. Group messages don't work like that.
Yes, they do, you stupid cow. I am currently in a hostage situation. I mean, a family group chat. And I can tell you, I can see when people have read it. Now, so yeah, no, nice try. Okay, I can't. Look, I cannot be kind anymore. So we are going to skip ahead.
Put your left hand on the Bible, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay. Once you're seated and comfortable, can you state your full name for the record and spell your last name, please?
Marissa Caneiro, Caneiro.
Okay. Ms. Caneiro, I just asked you to speak up. You probably heard me say that a couple times. Just speak up so juror number 15 and 16 can hear you. Go ahead, counsel.
Good morning, Marissa. Good afternoon, Marissa. Can you just introduce yourself briefly to the jury?
I'm Marissa, and I'm Paul's youngest daughter.
And we heard a lot yesterday from your sister Katie about what transpired on November 20th of 2018. So I just want to focus you in on one specific thing that happened. At a certain point, were you at the police station with your family?
Yes.
And during that time,
What is this lip thing she's doing? This might be a self-comforting thing, but it's very, very suspicious looking. And again, while it might be something completely innocuous, most people are not going to give you the benefit of the doubt with the additional factors and variables being that your dad is all the guilty, and we just don't want to sit through another "my dad was a really nice guy." That really doesn't, again, your dad being a good dad to you didn't preclude. It's like the BTK dad was allegedly a good dad. Ted Bundy was allegedly a really good LDS Mormon before he wasn't. These people can wear masks, and this isn't the point. So, oh, good Lord, this is going to be painful. I mean, let's get into this.
were you taken downstairs to a conference room?
Yes.
And while you were in that conference room with your dad, did you learn any information about what was happening with your family?
When we were alone, me and him.
Yeah, here, I'll back up. At some point, are you in the conference room with your entire family?
Yes.
Okay. And thereafter, were certain members of your family taken out, and were you left alone with your dad in the conference room?
Yes. My mom and sister were taken out of the room, and then it was just me and my dad in there.
Okay. And when it was just you and your dad, was there a point in time where you learned information about your family?
Yes. A police officer came in and he told me and my dad.
Denise, this is actually his other daughter, Marissa. Marissa was the younger daughter. Again, I I really question the strategy of bringing up Paul's family's grievances as far as how they were treated at the police station. Now, could the police maybe have been more attentive to their needs? But they were also dealing with a very chaotic double arson, potentially quadruple homicide, and maybe they did not have the time to be emotional support cuddlers for the Caneiro family. Now, this has also, I believe, been talked about by the judge that he would. These are fairly serious allegations that they are making against the state in large, but the police, that they were basically coerced into giving statements.
That
You're saying, sorry.
Just say,
Did you learn what happened, just without saying what was said, did you learn what had happened with your Uncle Keith and Jennifer and their family?
yes,
And did you learn that they were deceased?
yes.
And can you just describe that moment that you learned that and what your reaction was and what your dad's reaction was?
Relevance.
you can answer as it relates to your dad.
When they told us that everyone died, my dad was really upset and crying. He felt
I have only been around one person who learned that someone they loved died. And the sound that came out of this person's throat, I don't ever want to hear it again. I heard it again in the Lake and Riley trial. That primal, soul-tearing grief that can only be voiced in this howl of misery and pain. I cannot even describe it. When you see someone who gets the news like that, you can't be this blasé about it. And I know I am a tismy Vulcan, okay? I don't like upset. I don't like emotions. They are entirely too messy, but I can tell you from the bottom of my heart, I hope I never hear that again. And it's not something that you can be blasé or flippant or anything, or at least I can't. I can't disassociate from it to be this kind of flat affecty about it. Maybe this is how she comforts herself. So again, I am trying to give more grace, but it is a very odd of affect, again, for a very emotional moment.
to the floor, and I was sitting across from him at that point. So I got up and I was on the floor with him, just holding him. He was crying a lot and my shoulder was wet. And then eventually they told me I had to leave the room as well. So I don't know what else happened.
When you were in the room with your dad and he was upset and crying on your shoulder, did you say he fell?
Yeah, he was sitting on the chair and then he fell to his knees. So I went over there and I was just holding him up.
Now, this seems to be a very clunky way to explain the very big bruising on Paul's ribs and knee and other parts of his body that wasn't very apparent the day of the incident, but became more and more noticeable after Paul was incarcerated. So this appears to me to be a very clunky way to try to tie up the loose end of, oh, well, Paul, he went into the police station and it did appear that he only had this little bruise on his hand. The problem with reality is that he had in the following days, very significant bruises up and down his arms, along his rib cage, and different other places that might be involved in, fighting a family and unaliving them. So this seems to me to be a very clunky way to explain these other bruises that started to appear after he was incarcerated. But then again, that is almost too smart. That is too smart and multi-level thinking for this defense. So I have probably just wasted your time talking about a theory that is going to go nowhere.
And about how long were you on the ground with your dad before you were taken out of the room during this time?
Maybe like 3 to 5 minutes.
That's all I have.
Ross?
Just a quick question. When you were in the police department, ma'am, you were allowed to keep your cell phone on you, right?
Yes.
And all of your family members were allowed to keep their cell phones, is that correct?
Yes.
Okay. And then eventually you ended up giving a statement, is that right?
Yes.
Okay, and then you left that night, correct?
Yes.
I have nothing further.
Can I ask a follow-up?
Sure.
Did you have cell phone service when you were?
No.
Oh, poor Caneiro family. They didn't have Wi-Fi. Won't someone think, could we get a telephone? Could we get a fucking GoFundMe for them? They were without Wi-Fi. Oh my God. Sarah McLachlan, someone get here. We need the sad music. In the arms of the angel, far away from here. They were without Wi-Fi? Won't someone think of the Caneiros? You have got to be fucking kidding me.
You can step down, thank you.
Oh, please bring up the wife. Bring up the wife. Bring up the wife. Come on. I want to see.
Call the next witness.
Can we approach?
Okay.
Bring up the wife. Bring up the wife or Paul. Or are they going to rest on that? Jesus, was that your rest? The state ends with the most poignant testimony I've seen this year. The defense rests with, he cried and my shirt was wet, so I know he cried it. Yeah, Paul, at this point you should be crying. All right, let's. Oh, I'm sorry.
Hey,
Yes.
research.
This was the younger daughter. Sorry. What did they send the jury out? For the day or?
All right, I'll be back home in 5 minutes.
Yeah, that does kind of change things. Or let's be real. Paul is not the most, let's say, Paul would have the latest and greatest iPhone, but would the rest of his family have it? Maybe, maybe not. Who knows? Maybe Paul was able to get Wi-Fi, but his daughters didn't have the latest iPhone. I'm surprised they're not suing the state because Paul didn't get them the best iPhone, so they didn't have Wi-Fi, which I guess is a human right. And maybe we are behind. Oh, yes. Thank you, God.
For 17, which includes the projectile from the brain, and how.
I guess they did let the jury go. I'm guessing if I have any sort of read on this, I think that the defense is going to rest tomorrow. While it would possibly be the dumbest thing in the history of law to do, I don't think that they're going to bring Paul to testify. If they do, I foresee them closing with Paul. But I do foresee us being possibly at the stage for closing statements tomorrow. Possibly.
It was impacted as it went through Keith's skull. 17.1 circles the projectiles. However, in the circling of the projectiles, it kind of goes through the projectile and in some ways obscures the actual photo. 17 is a clearer shot of these items. So therefore, I don't find them to be cumulative. I find them to each have their own evidential value. And for that reason, I'm going to include slide 17 and 17.1. They're both included in evidence. Okay. Ms. Massalone, was that the only area of the photo book, or was there some other area that we needed to discuss? Mr. Decker, I'm sorry, I stole your book.
That's okay.
Thank you, sir.
Judge, we have no other issue. There was one other photo that we discussed with the state. They're not admitting it, and that's it. Okay.
So the only one that we have left then to discuss at some point is A, after you receive it, correct?
I just reviewed it, Judge. I have no objection.
Okay, so A, as noted, is in. So the final photo book, Mr. Decker, will be where for when summations start tomorrow? Is that the book that you have in front of you?
There's two books.
There's two books. Okay. So I just want to make sure that final book is in a spot. Everyone is agreement with it. I don't want it to get lost for any reason. I don't mean that in a negative way. I'm not saying you guys would do that. It's just making sure that we don't want anything going into the jury room except for exactly what we all agree to. Okay. All right. Thank you for that.
Judge, I did previously show the state of photos that we were likely intending to admit. They indicated they didn't have an objection, but I didn't have an opportunity to choose our point ones that we were going to show. So I have them now. It's not too many. I can hand them to the state if they want to take a quick look.
Okay.
See if there's any.
Yeah, we'll have time for that. All right. So I'm going to move things along. I'm going to remind us of what we already have in evidence, and then we can go over, Ms. Wallace, if there's items that I may blow past that we need to talk about, just stop me, okay?
Okay.
All right, so S2 is in evidence. S7 through S12, including the point 1, point 2, point 3, point 4, point 5, and number 12, all in evidence. S17 through S19 in evidence, including proposals A, B, and C. S26 in evidence. S28 in evidence. S29 in evidence, including point 1 through point 10. S30.
I'm sorry. I think the points were in evidence for that.
Oh yeah, you're right, and not the main document. You're right. You're right. Sorry about that. So it's just 29.1 through 29.10 are in evidence, not the overall statements. I apologize. Same with.
And then you guys, since it looks like we are going to be going to closing arguments tomorrow, I do have a poll up to see what you guys want to look at while we're in verdict watch. And do not be shocked if this takes a couple days to deliberate. Do remember that the jurors have not had a chance to decompress at all. So I would be shocked if this was a speedy verdict. Now, maybe it's one of those cases that the state was so overwhelming and the closings will be so noticeably different that it will be a lot interesting. But it is interesting Sorry, I do try to catch the door. It's a very heavy door to my room, so I try to catch it when Mr. Mo is coming in and out, but I don't always get it. So it will be interesting to see because I could see it going both ways, but I do tend to think it is going to be more likely that this is going to be a longer deliberation just with the amount of evidence and the amount of time that this trial has been on.
30 is just points 1 through 19. That will be in evidence, not the entire statement. The next were the area of S33 through S38. We discussed them. I think we said that 33.1, 34.1, 35.1 were in evidence. However, is there anything else from 33 through 38 that we needed to have a discussion about or that was being moved or not moved?
No, Judge, we looked at them. We're good with where we left off.
Okay. Right. So it's just 33.1, 34.1, and 35.1. Otherwise, not the entire document. And 36, 37, and 38, there was no point ones on those, so they are not being moved. S40, we're moving in A and B. But that's the only areas. Okay, we had we were going to revisit S42 and 43. Ms. Wallace, where are we with those?
We just spoke to Mr. Murray. We are good with S42 being moved in, but not S43.
Okay. So you're not attempting to move in 43, correct?
That's correct.
All right. And you're good with that, Mr. Murray?
Yeah, I took another look at 42, and I think that
the large bulk of it was testified to already, so we don't have an issue with that.
Okay, great. Thank you. S44 through S53, all in evidence. Next one is S61, A and B are in evidence. The next were the S60 through 65 that we reserved on. Did we come to an agreement on that?
Judge, the state's position is still that those should be moved in. I would note that we did mark, or we did look at, and we put up the index on that, which is what Detective Nicolarese actually drew on at one point. And that index had the dates of 4/13, 9/13, 9/17, and then 11/5. So I understand, obviously, that's the state's position.
Okay. And the defense's position, go ahead. I know you have objected to.
Youngest Most Feral was like, I see a Burger King cup. And I was like, no, I've just been refilling pop in the Burger King cup because I really don't feel like dirtying another dish right now. And he's like, well, you have another cup. And I'm like, well, that might have a little bit of an adult beverage in it. So like, when did you become my parole officer? Go do your homework if you've got homework. You can have 10 minutes to relax and decompress. And then you need to do your homework.
Do it because you said it was confusing, the way that you have to read it. It was a little difficult. But was there anything else that you wanted to add to that?
Judge, if the court is inclined to allow it, then I would just ask that they be like page numbered, so that at least if they do get disorganized, there's some sort of mechanism to put them back in order.
Haven't we all had enough of Starbucks? Why do we need like 20? Look, I'm not a coffee drinker, so I don't understand the miraculousness of Starbucks. Also, I'm too damn cheap because do you know what's really, really good, probably and completely full of sugar? But gas station cappuccino, and those are like $1.99. And if I'm gonna drink something that's full of sugar and bad for me, I'm always gonna pick a milkshake. I really am.
Perhaps they can just number them.
That's fair. That's fair. I'm going to allow them in, and I'm going to ask for them to have page numbers. I agree that the page numbers would be helpful. I do find them to be relevant under the circumstances they were testified to. And I do find that under the circumstances, the jurors should have them. But can we have Ms. Wallace have somebody do some page markings on these? I know it's going to be a lot to do tonight.
Yes, we could probably put them in binders too. We can even print the index. I don't know if that's something that'd probably be helpful, having the index on it as well.
Fine too. Just as long as let the defense see that at some point.
Okay. And I was just gonna add, if they're gonna put it in binders, that makes sense, maybe like a cover page with the date to organize them by date.
Yeah, that's fine.
Again, our initial position is an objection, but that's.
Of course. Yep, your objection is definitely noted from before. It's noted again here today, but I'm going to allow it in. However, I do agree with you that page numbers are helpful. Okay. S66, A and B both in. S69 and 70 both in. Next is S74. All parts of S74, A, B, C, D, and D1 all in. S76, including clips A through D, all in evidence. S78 in evidence. S93 in evidence. S94 in evidence. S96, and I believe it's just B in evidence because the first 911 call was not something that was a hang up or something.
That's correct, Judge.
Okay. So it's just B.
Yes.
S99 in evidence. 101 and 102 in evidence. S155 through 166, all in evidence. S168 through 177 in evidence. We reserved
Oh, I didn't know that.
178, which was the padlock Pelican Storm case, 2050 with a knife flashlight. You guys had the opportunity to discuss that again. Has that been worked out or no?
I don't think it's been worked out, Judge. It's a locked case which was opened for the purposes of removing the gun and sending it for testing to the state police. We submit that obviously there was a lot of weapons that we didn't utilize in front of this jury, but that is one of the handguns that was tested, and that was the way it was found.
Okay. All right. Ms. Mastellone, I know you objected to it, but I'll allow you to, if you want to object any further now, or if there's anything else you want to add.
Nothing to add, Judge, just objection.
Okay. I find under the circumstances that the jury, because the jury's not going to physically have these items, that it's more of the testimony anyway. However, I do find under these circumstances that not all items were sent to the state police lab. This one was. If the jurors for some reason had some reason to want to see it, it will be in evidence for them to be able to see. I don't know if they even will, but I do find that the probative value outweighs any prejudice to the defendant. Again, for the reasons that these items, as it relates to all of these guns that were located at 27 Tilton, they're not all going to be physically in evidence, so I have no issue with it. All right, S179, 180, 181 are in evidence. S183 through.
I also really appreciate this judge. He's much better at doing it than I am. To be fair, I hold a grudge, and don't you dare ever effing roll your eyes at me. But I appreciate the way he tore this defense attorney a new one, but as soon as he was in front of the jury, he was nothing but professional. I mean, and ever since then, working with her outside the presence of the jury as well, he's gone back to being respectful and professional. So I appreciate that because that's not something that I excel in. I hold a grudge. I'm a grudgeinator. I hold one, and rolling your eyes is about the worst thing you can do to me. I'm just saying, I don't take offense to much. I try to give people grace, but rolling your eyes at me is one of those things where I'm like, oh, you better pray Jesus.
196, all in evidence. S214 in evidence. S222 is a continuation of the same argument from before, dealing with this small plastic bin with 6 magazines and 11 finished lowers from basement of 27 Tilton. Ms. Wallace or Mr. Decker, anything else you want to add to that? Ms. Meslow, I know you objected to it before. I'm just giving you the opportunity if you wanted to say anything else.
Judge, I'm just gonna I mean, other than the text messages, when we're dealing with the ballistics, since that was Mr. Murray's witness, I'll let him.
All right. So 222, we don't have an objection to.
Okay. That's an evidence. All right. S230.
Is the court preserve on 225 or was 225 previously ruled in evidence?
I have it crossed off that I was not allowing it in evidence, 225 or 226.
Okay.
The arguments can be made, but I said no to the actual items going in. 230, 231, A through E, and then 233 up to 242, all in evidence. 256 A and B in evidence. 261, 261.1, 262, 62.1, 263, and all of its subparts A through M, and there was a lot of point ones added. They're all in evidence. 264 in evidence. Then 270, 271, to include A, B, C, D, E, F, and then 271 A1 and 271 C1, all in evidence. 272 in evidence, 273 and 274 in evidence. 285 and its subparts A and B and point 1 and point 2 in evidence. 299 through 338, all in evidence. 347 in evidence. 375 in evidence. 391 in evidence. 392A, E, and H, all in evidence. 405 in evidence. 407 in evidence. 418 and 419 in evidence. 437 in evidence. 467 in evidence. 474 in evidence. Then we said we were going to hold off on 476 through 480. I don't know if there was any more consideration as it relates to the DNA from the state. I know that the defense is going to be asking for certain items. I'm not saying I'm going to put them in. I'm just saying that they wanted to move certain items of their evidence from their experts. So I'm asking you what your intention is with these items.
Just trying to recall what they wanted to put in from their expert.
Mr. Murray, that was your witness as it
Oh,
relates
God.
to Dr. Reich.
Well, Judge,
Dr. Steven Spurgler? No. The jury doesn't need to be tormented with any of his color charts that do nothing to demystify DNA. If I were the jury, I would ask for those back so I could crumple them up and light them on fire in a ritual to restore the balance in science.
There was also the exhibits that were published during Daniel Reed's testimony. I think we didn't really get to those last week when we talked about.
Okay, which ones were you looking at there? So Mr. Decker will be able to argue, or Ms. Wallace, whomever.
that was Ms. Stallone's witness. On cross, she can correct me if I'm wrong, but I would imagine it was 140.
Also, hey, Milton, what would you say you do here? You have been as useful as a sweater knitted out of belly button lint from the 1970s onward. What would you say you do here? Because you've obviously not helped Tweedledee or Tweedledummer. So again, I mean, hey, it's a good job if you got it sitting there doing nothing. Just, there you go. Oh God, that is
That's 140 to
terrifying, but
143 or
probably
D?
true.
D 140 to 140.
Okay.
Just they were and the state, when we initially showed it to them, they didn't have an objection. There was nothing additional, I think, that we had, or from his poem.
One is the one you wrote on. I think that's 140, 141, right?
Yes, 140 is Bodie's chart, like the ratio chart that I wrote on.
Yeah.
141 is the allele chart that's highlighted. And then we had the two deconvolution reports, which really there was, not the whole thing was referenced, but portions of it. So that's what we were initially asking to be entered into evidence. I don't recall what the state was asking for. I think we wanted an opportunity to confer with them. We just haven't spoken about that yet.
I mean, I'm just struggling with the idea that, I mean, obviously, we want the Bodie results in on that chart, but there's other results that are in reports. And then we just have certain documents, just because they're highlighted, doesn't make them any more evidential. I mean, I think it's
Well,
kind of,
there's writing on 140 that's testimonial, and then there was writing on 140.1, which Ms. Wallace got back up, used the same document, and then we pointed that out. And we made that a different exhibit. I have no problem with that timeline going in for both sides. I think it's fair. It's testimonial on the document. Ms. Wallace, I forget what you marked when you got up and you asked for it, and then we
On the DNA report switch or
on the Bodie report, and then there was the back of a notepad that was written on. If you guys remember, it was Miss Mastallone's notepad.
Because that was the timeline. That was through.
That's a different timeline?
Yes.
I'm sorry.
it's okay.
Mr. Murray's notepad.
Technically, it's a .1 exhibit because we didn't preserve the notepad as an independent document.
Valid point.
Fortunately.
Right. Why, you don't want all your notes to be put in evidence?
I prefer not.
All right. All right, so you're
Actually, I would subpoena his notes. I would study them like the Zapruder film. There has got to be an explanation for how he thought. Because look, you can tell that both of these people thought that this was a good strategy, thought that they were going in with unearned and hilarious overconfidence, but they had to have some sort of reasoning. And I want to figure that out because it is so anathema to every sort of reasoning I've ever fathomed that it's kind of fascinating. That's the kind of thing that I like to look at. Sure, that says I'm just an awesome person and not crazy.
position is what as it relates to the Bodie chart?
The Bodie chart, I'm 100% comfortable with that going in.
All right, so that's
Obviously,
2.6. That's D140 going in.
and D4 is it 141? I have no issue with the allele chart table going in.
I don't see the value of the deconvolution report because there's areas of the report that was not testified to. However, I mean, the exhibits were shown on the screen. I think it's fair comment by both sides. Both sides use the deconvolution reports, less used by the state, more used by the defense. But I have no problem with those being discussed in detail if you want to discuss them. It's just that the entire report, and there's a lot of areas of the report that was not discussed, and I don't want them getting confused as to what each thing means or and trying to figure it out. So
I agree, Judge. I don't necessarily need the entire reporting, but perhaps just the portions that were published.
then you're going to have to redact the front page because there's items on the front page that some were testified to, some were not, as the Gelman-Rubin and the fallout ratio or the burnout ratio. Some of the stuff wasn't even touched.
Wait, there's a fallout lore dump that we could have access to through this evidence? Is it about the Brotherhood or Enclave?
Judge, if we had a little bit more time to think about it, then, we could perhaps come up with a solution. I'm not sure in this moment. I mean, again, things that were published, I think, the jury should have access to it. I mean, maybe we could.
So I think there were other terms of art like the Gelman-Hildebrandt scale or whatever he was talking about. There are certain other kind of terms of art or numbers on these reports, these deconvolution reports, that I think basically what the judge is trying to explain to the defense is, I understand that you think this is good evidence to you, but you are in fact sending back things to the jury that you're going to have to redact that might make them wonder what is redacted. So really think about this. Is it that important for you to have this information in? Do you think you can rely on the testimony that you elicited from your expert? So basically, because they didn't go into them on the stand, I don't know what these terms mean, but that's basically what the judge is pointing out, that you already have really, really kind of esoteric knowledge that people don't generally have about DNA that you're asking the jury to understand and make a judgment on. It might not be a good idea to send back other things that are either going to have to be redacted, or you're going to send it back there and the jury's going to ask questions about, well, what does such and such mean? And it might screw up deliberations because the state and the judge, since it wasn't testified to, can't give them that information. So I do like that this judge is trying to give wisdom, not in a condescending way, which is how I would do it. I would literally get a whiteboard out and start talking in stupid speech and tell her that I'm going to explain this in crayon for the slows. So he's much better at giving gentle kind of, hey, think about this. That the defense just seems incapable of grasping.
Agree that they don't have it back there in the jury room, but if they wanted to look at it, we could allow them to see portions if they had a request.
Can I have ID 142, 143, please? Thank you.
Yeah, so both front tables are defense, and then the state is these back tables. Now, initially, I thought that these interns were associated with the defense, but it is a very odd setup. It is very odd setup. I don't quite understand it, and it does put the defendant very very close to the witness box, and I don't find that I like that. But I do understand the wisdom if you have a small courtroom that you don't want the defendant near, uh, the the gallery where they might have family members that try to pass them something or things like that. So I guess they're doing the best that they can with the current courtroom, but it's just a very odd setup. Defense, I will make a bet with you. I continue to have the crime against foodmanity that is the pumpkin spice ramen noodles. If the jury actually asks for whatever BS report you're wanting to put in from your expert, if they ask for any information about from your expert witness, I will fire up the electric kettle, and I will at least take a bite of that pumpkin spiced ramen noodle. I don't know why I just said that, but I just have a feeling that no one is going to give their expert the time of day.
You were standing up, Mr. Decker. I don't know if you want to say something.
I guess, Judge, I'm just trying to figure out, I just don't want to confuse the jury on, like, they're not actually getting the DNA conclusions in some respects, like the state police, the actual expert report from the analyst. But then they're getting like deconvolution reports that are part of the analysis leading to a conclusion, but they're just not getting the conclusion. Just because an exhibit was shown or published, I think the way I look at it is if I would have shown Chris Clayton his report and said, let me publish this and have him underline his conclusion, I don't think it would make the report any more admissible just because he pointed that out. I think it would be kind of like a great way to backdoor every expert report. We're all certainly going to talk about the DNA conclusions in summation and ballistics and stuff like that. But if we're going with the expert reports aren't coming in, I think that's kind of where we're at.
I hear you. Go ahead, Ms. Vassalone.
Judge, I really haven't had time to think about it, but maybe if it just in the event that they ask for a readback, it could be made available to them. If it was something that if it was a specific area of testimony that they were interested in.
Yeah, I'm not going to allow the physical documents in because a lot of it was not testified to. Anybody can comment on it. If it becomes an issue, excuse me, if it becomes an issue on a readback, we can discuss it at that point. But I'm not going to allow it in for now for the same reasons that I didn't allow in other reports from either side. Just like I wouldn't allow Reich's report in, I wouldn't allow some of these deconvolution reports because there's so much information on here. I find that under 403 it would be confusing to the jury to fully understand all of it. And I would not want them to go back and trying to do their own, become their own expert in DNA analysis. So I'm not going to allow 142 and 143. But again, if something comes up during a readback, then we can discuss it then.
Should I just ask one question?
Sure, sure.
We didn't get to, I understand the court's ruling on Dr. Wright's report. There was also the PowerPoint presentation.
Yeah, let's take them one at a time. I'll get to you. I didn't mean to jump ahead. I was just using that as an example that I throughout all of the state's exhibits, I didn't allow any investigation reports or any other person's reports. I was only drawing the same analysis, but I didn't get to that yet. I didn't know you were even trying to move it. So let's wait until we get there, if you don't mind. So can we go back to the state? So just so the record remains clear. Considering that the court is not allowing deconvolution reports, is there any request for 476, 477, 478, 479, and 480 for that example?
No, Judge, under the same ruling, I would suggest that would be consistent.
All right, so no to all of those. And again, the free game, it's free reign to argue whatever you need. And then I think the only other one was the photograph of the defendant and his daughter, 501. Is that being moved or is that not being moved? I don't recall.
No, Judge, I don't think that foundation was properly accepted by the court.
And anything that happened today in any of the exhibits that occurred, or do you want to wait to hear what the defense is going to request before you get into that? It was 502 through 505, I would assume, because the last one I had was 501.
We'll be moving, seeking to move 504 and 505. This is 502 and 503. Okay, thank you. Yeah, so the state would be seeking to move 504 and 505.
504 and 505 deal with the cell phone
Yes, that
and the
is.
extraction.
Yes, that's correct. 504 is the first page of that. And then 505 is another page that was shown.
Okay, so my question to you is that the state, and again, I understand how we got to where we are today, but we don't need to go back to that from this morning. But if it was an agreement not to put in the phone, the screenshot of the phone where it says it's red, how do I put in 504 and 505 after the testimony is already out there, but not the reports?
Yes, I didn't realize there was an agreement not to put, I don't think I understood that, not to move in the screenshot.
Well, it wasn't, and I know we discussed it, and I believe what Ms. Massalone said, and I will not put words in her mouth, she can say whatever she remembers, is that it was my understanding that she was not intending on doing it. However, if something came up, she would let us know at sidebar that there was some questions that she wanted to ask, which she did not do. So with that being said, that is the reason why that I'm just wondering, considering we did not put any report in about this.
Be careful.
If that's your plan. If you want to put it in, then I'll hear from the defense.
I mean, I think the state, I think the state would be seeking to move that in. There was testimony about the facts of the text message itself. This was shown to the witness. We marked it, we showed it to her. So I think for purposes of completeness, the state would be seeking to move these two documents in.
Okay. I'm here from the defense as it relates to 504 and 505.
Judge Laporte is correct. I mean, the defense was never intending to use the screenshot but rather to simply elicit her testimony, which reflected her recollection of what occurred. I did not question her on the screenshot, and I sort of found out in live time that the prosecutors were going to question her about the group chat, which they did, and she wasn't able to, I guess the foundation was not really laid as far as the admissibility because she didn't recognize it. She's never seen it before. The prosecutor asked her, does this appear to be a group chat? And she said no. And so my position would be that either none of it comes in, which that was what I assumed was the agreement as well, or that in fairness, they should all go in because again, it goes to her credibility and completeness. She's not lying when she says that it is a text message between her and her aunt that says red. And we know that she's not lying because she testified to it under oath. We have a screenshot of it, and the prosecutors themselves saw the screenshot. They saw her phone earlier today where she showed it to them. If they want to suggest that it's a group chat as opposed to a single screenshot, if they want to show that that's what the extraction shows, then fine. But then we should also be able to show what this witness was looking at, her own phone and the screenshot. So I think as a matter of completeness, it should be nothing, which was originally what we assumed, and I didn't question her about it, or it should be all three items.
Anything else?
No, Judge, I'll leave it in the court's discretion.
I think that the testimony was clear. I'm not going to allow the document in because I'm not allowing the screenshot in under these circumstances. But the testimony is out there. The document can be referred to as part of your summation as to to remind them of the testimony. I'm not sure if I actually agree with the defense that because she testified under oath that she was telling the truth. I don't know if she is or she's not. All I know is what the extractions say. She saw extractions from the defense. She recognized it. She saw an extraction from the state. She doesn't recognize it. All I know is that I'm not going to allow them in, but I will allow the state to comment on those items 504 and 505. So that they will not be in evidence. Now let's go.
Now, what will be interesting to see is whether the male prosecutor or the female prosecutor does the closing statements. And with the female prosecutor, it was evident that, and again, she had more of the information of actually the horror that these children and this family went through. Because I was a little leery of her kind of, and it was only a very slight break in composure. I will say that it did give me more pause because we had just come from Uvalde. But I think what we will see in this closing statement, let me pull up the opening for you, where I did get worried. Okay. I know it's some, okay, this isn't the view I'm used to. So let me go to, I think maybe it's, okay, wait. I am a professional-ish person. Let me put on closed captioning because I can scrub through and kind of get to where, okay, maybe this is it.
He got him in the lower back and multiple times in the head. Once Keith was out of the way, executed on the spot, no longer able to protect his family, The defendant then went inside his brother's house, a home he'd been in countless times before, a home you'll learn he knew like the back of his hand, a home where Keith's wife and children were. And in there, in the chaos and confusion, having been awoken from sleep, in the shock and terror of having their home invaded, and in the dark, the defendant hunted them down. He stabbed his sister-in-law, Jennifer, multiple times in her back, her chest, and her abdomen, and he shot her in the head. He stabbed his nephew, Jesse, multiple times in his upper body and threw his arm into his chest. And he stabbed his niece, Sophia, 17.
Now, I'm not going to go into this, but you could tell that this really bothered her. And I remember getting very, very fearful that we were going to be subjected to another case where we were going to get our souls ripped out. And I think she was actually tame for what we learned for what but I don't see her being as tame. I see that the rebuttal, again, I can't remember if New Jersey is one of the Commonwealth states that just does the state and then the defense and no rebuttal. I can't remember. But I remember being very worried when she showed such obvious emotiveness during this, because I was dealing with just coming back from Uvalde, or coming through Uvalde. But I do think it is a testament to what a good lawyer she and the other state's attorney have really done a good job of using the facts. They have the facts on their side. But I do expect, and really, I expect that she's going to lean more heavily into emotional stuff and the horror that we know about. So I do expect it to be a more emotional argument this time. And I find that it's appropriate this time. I find that we are getting into arguments, and it's appropriate to be a little bit more emotional about it. I think that this is a case that if you're able to be as blasé as both of the sisters are, it comes across as incredibly off-putting. So I think that I would expect there to be, the state has done a very good job being very measured, and I think that they're going to be heartbreaking in their measured tone. I think that they are going to bring it home. I hope, because for the most part, I have really respected and liked this state's attorney, or this state team. And I wish that I like it when both sides have merit, when both sides have oh, thank you, Tammy. Sorry, I forgot. I like it when both sides are good. I don't like having a trial where I have to scrub through the defense because they irritate me with stupidity. I wish Paul had a better defense strategy, but it will be interesting to see what. Yes, I know. We're almost done, sir.
To the D exhibits.
I do have a concern about, I don't know what the state's comments as far as that exhibit, because, I mean, it would have to be consistent with the testimony. Otherwise, the state is essentially testifying. So I'm not sure what that means, that the state can comment on it. I mean, I think that the defense and the state could meet and confer, and we could come to an agreement if we had a moment. But, you know, obviously it wouldn't be appropriate for the state to be testifying to things that weren't testified to by this witness in their closing. As to the witness's credibility, Judge, again, that the state saw the phone, so I think that speaks for itself.
I didn't see the phone. Is that what you just said? I didn't see the phone. I have no idea what the phone shows and what it doesn't show, but it's not, I don't need to see it. It's the back and forth from you all. I've made my ruling as it relates to this. If the state and defense want to confer as to what they're going to say, they're experienced prosecutors. I told them what they can and they can't say.
Yes, I love you. Oh, you are ridiculous, sir.
It's within the testimony, and they know what she said and what she didn't say and how it was confronted.
Stop.
And what the report, what questions were asked about the report. So I'm going to leave it at that. I'm not telling them what to say or what not to say. I'm not going to get in the middle of that because that's a different issue that I want to stay away from. So I'll leave it at that. All right, let's go to the defense exhibits. Mr. Murray, what I had, tell me if I'm wrong, your first exhibit that you moved in was D55.
That's right.
Okay. And then we had D64,
Yes.
D71 and D71.1.
Yes, those were published exhibits that we were moving.
Okay. 106.
106, yes.
Okay. 114.
Yes.
122.
Yes.
And then we're to what we discussed. Now, from your DNA, tell us which ones you're looking to move.
So I think there's an agreement on the 140 and 141.
Okay.
Those were the marked up exhibits.
Is that correct, Ms. Wallace?
That's correct.
Okay.
The court's ruled on 142 and 143.
Right.
Then we had D150, which was published, which was the PowerPoint from Dr. Strike. Now, obviously, we're not looking to get in his report, but I think similar to the testimony of Detective Bassender, where, you know, it's not the entirety of a record that's coming in, but
Stop,
a chart
sir.
that the jury is
Not the
going to have
legs.
available to them. You know, I kind of see the PowerPoint to an extent the same way as those charts. We're planning to offer that.
Okay. And that was, tell me the number, because mine's, your exhibit list stops at 144 for me.
Oh, so that's D150.
D150. State's position.
I mean, I just think it's another report that he drafted. We're leaving out a lot of DNA conclusions in this case. They're not getting them other than what they heard in the witness stand and what they're going to hear from me and or, you know, defense counsel tomorrow. So I just think
Oh, interesting. So it is going to be the male prosecutor that is going to do the closings. Really, the only reason I'm hanging on for this testimony is to try to get a understanding of time limits. The state has been really good with their grasp on this case that I think this won't be a matter of, God, I hope they don't take up a lot of time. And even in their insanity and ridiculousness, the defense is going to be entertaining. But I do want to kind of get an idea of time limits so I can decide whether we're going to start directly on time and have a shorter mornings with Mo, or do what we've been doing, start at 10 and go from there. So that's kind of why we're hanging on for, because I know this isn't the most fun test or fun stuff to watch all the time.
that they get some results and not the others.
Can I see the PowerPoint? Do you have a physical copy of that?
Summary of voluminous documents. I mean, just for the record, the passenger charts were under Rule 2006 summary of voluminous documents.
Sir,
Just to demonstrate.
sir, President Biden, stop. Stop snip.
President Biden?
Yes, it was a joke because he likes to sniff hair. What are you chewing? No, that has electricity.
That room. The other box that I brought this morning. All right.
That-
Here. I could either go get it now.
Oh, and welcome. Oh, crud. I think Squid's Raiders came in. Sorry, I've been trying to keep track of Feral and a cat who's becoming.
All right.
Howdy, howdy, Feral
So this
Raiders.
is page
Or
one.
not Feral, good
This is
lord,
page
Squid
one.
Pro Quo.
All right, let's go to page 2.
Oh, for the love of Cheetos. Look, I am severely just wanting to find out how long you guys
Page
have
9.
as a timeline for tomorrow. Squid Raiders, if you guys are just joining, it looks like we are going to be looking at closing statements in the Paul Caneiro case. The defense has been, to say disjointed and convoluted is kind of high praise. It has been extremely ridiculous, and it does look like we are coming to the end of this. It was a bit of a roller coaster today. Apparently, the defense decided to commit a couple discovery violations. Am I roboting or? Okay. So I am simply trying to figure out how long we are looking at for opening statements, because depending on time limits, we will either start when the court starts, or we will do our kind of delay start. So, and it looks like you guys voted to be checking in. We will be starting the Faust trial during verdict watch, and I'm of two minds of this case. I can foresee it. As odd as it sounds, the jury might be so mother effing done that they have already started to, make their own internal kind of judgments on what they believe, what they don't, that they might find that when they do the initial vote, they don't have any disagreements. So I do wonder if we are going to get an extremely short verdict, or if we're going to get several days of verdict watch. I do believe that I could see it going either way, and juries are very interesting. So we will be getting into the Georgia Faust case on verdict watch tomorrow.
Page 10.
This is the defense trying to bring in an expert report on DNA. The judge is not budging. The state hasn't. Basically, experts aren't allowed to give their report. They have the jury has to go by the testimony that was brought in, not the experts' reports. So the defense is working.
Used by the defense expert in this case, which argues that, or that the defense's expert indicated that while some of the results were reliable, it also talks about how there were certain areas that potentially of another person being involved in this, another person's profile was at the scene. The court finds, as it relates to third-party guilt, it's going to allow only certain portions of.
Yeah, that's where I'm torn, because most of the time I'm the first person to say, guys, I know we all want the, screw you kind of funny jury marching out and marching right back in to deliver guilty, but don't expect a quick verdict, even if we think we all know what we saw and it was clear as day. But this might be one, given the amount of time, given the amount of evidence and what the defense has put up, that I honestly don't know how anyone could have any reasonable doubt after the state rested. And the defense has done nothing to change my mind.
This to be allowed to be used. I'm going to allow slide 2. Go to slide 10 so everyone sees it. 10 will be allowed. 11,
Uh,
12,
What's the cat doing?
which shows no
What's in your hair?
unknown contributors
Our wig off.
out of fairness to the state. And then slide 13, where that shows an untouched Bodie report as to relates to not only the people that were excluded at locations, included at certain locations, but it also allows for the state, as it relates to the reliable results that were testified to, that he has a document that is not that has not been touched or altered in any way. Mr. Decker, I understand from your perspective that how do we have the defense to have certain charts to be available when the state does not. It's the court's position, right, wrong, or indifferent, but the court's position is that the defense's theory in this case deals with the issue of Paul Caneiro. The court finds that there is, whether there is a rational basis or not, is not for the court to decide. But
he's like, whether I would buy this if this were a bench trial, I can't speculate, but honest to God, I've never seen a dumber thing. So no, I really don't understand this. We salute subtle petty.
That it was testified to. I'm going to allow it for this limited purpose, but I will also give you the ability to address that any way that you need to in your summation.
Thanks, Judge.
So it's 2, 10, 11, 12, and 13. Yeah, that, Mr. Murray?
Yeah, so that's what
That's
in
in
evidence.
2, 10, 11, 12, 13 in evidence. The rest of the slides are out.
Can the additional slides be commented on?
Yes.
Or part of a PowerPoint for closing?
Well,
Oh God.
they're not in evidence.
Right.
So they can be discussed, but they're not in evidence. So they shouldn't be on the screen. But these, you have carte blanche to do whatever you want with.
He's right here.
210, I'll show you.
Oh, not this.
Just for the.
Oh my God. He just said what exactly is allowed. Why is it so hard for you two to get this? Good Lord, these are the exact kind of students that I would have gotten in trouble for yelling at and making fun of in my class, because good God, how difficult is it to understand what the teacher just said?
2. Yes. 10. 11. 12. 13.
Oh my God, no, Kim K.
I guess we'll do the point ones next, but
Okay.
point ones are, I guess we'll do the point ones next, but
Okay.
this is, so we have, these are all D1 exhibits, so 1, then 6, 7, 9 through 12, 15 through 17, 21, 27 through 31, 34 through 38, 41,
43.
Four through
44 through 66.
Oh, Lord in heaven, please hurry up.
You want to,
I'm not objecting, I just want to.
no, I was talking about.
Sorry.
I agree, Ms. Wallace.
All of a sudden, it feels like.
You mind hitting the down arrow on that? And in the back, two, maybe. You want to go? Assuming you were done with the regulars.
I think that's it for regular funds.
Okay. So just give us one more, we're done, and then we'll move on to the charge.
1-1.1A, and then 100.2, 100.3, 101.2, 101.3. There was no amendment. 2.
From the state, correct? All right. We've gone over the charge. Everyone has the final draft. It's been marked as C9. All the other drafts have been marked and will be preserved. I know I've gone over it before. I'm just going to go over it. Stop me if anybody has any issues
I don't know.
with any part of it. I want to go over it one last time. We start with the general information, then the nature of the indictment, presumption of innocence, burden of proof, reasonable doubt, function of the court, judge's questioning. I've included in the request about sidebar conferences. I added that into the area to the function of the court, the first two paragraphs. I'm not sure all of it was necessary. However, in abundance of caution, I put it in. Judge's questioning, function of the jury, direct and circumstantial evidence. We forgot to read the stipulation to the jurors, so that we need to do that. So tomorrow morning, just a reminder, and I need that stipulation. So if you guys want to write it up right now, so that thank you, we'll add that in to the stipulation part. Credibility of witnesses, identification. Right after identification, so on page 9 and 55.
Did you do your homework? Your
Right
extra
there?
math?
Okay, good. My thought would be after identification, that's where I would put defendant's election not to testify before expert testimony. If you want it in a different spot, I can do that. I can wait until later after the statement of the defendant or narration testimony or defendant's recorded phone conversations. That's up to you. But I thought after the identification, Mr. Caneiro is denying his guilt, and also denying that it was him, that the state has to prove beyond a reasonable doubt. I thought that that was a safe place to put his election not to testify. Any objection to that? Or if you want it in a different spot, just tell me where you want it and that's where I'll put it.
That perhaps it would be best to put immediately before you begin the 2C portion of the. Yes.
Because
Yeah, because I'm sure wherever we put the paragraph that you should not take into account that Paul didn't testify is going to affect his guilt or not guilt. I'm sure the paragraph placement is really going to be the Hail Mary that you guys need as the defense.
So right after third party guilt is what you're saying?
Right.
Okay. That's where I'll put defendant's election not to testify.
Or criminal. Yes. Right. You're right. That's right.
Okay. Okay. So we'll add that in.
Thor, seriously?
And we'll obviously clean up
You turned-
the charge to make sure
turned
it
on the
just says
massager.
his, in the spots that it should just say that and take out the footnote at the bottom.
It's a free massage, Mommy.
That's a good way of thinking about it. Thanks.
So then we have identification,
Why did I say it like
expert
that?
testimony.
That's the dumbest way I've said it.
We have all of the experts on there. Prosecutors, can somebody remind me how to say Christopher, somebody's?
Tom as well. Has this been Kovic?
Wait,
Koviak?
Simkoviak.
Simkoviak? Okay.
Yeah, the judge is like, no chance am I going to just say something foreign. Look, that's what I do on my morning show.
All right. And Nazizan?
Yes.
Nazizan. All right. The rest of them. Was that our Cardenas?
Cardenas.
Cardenas. All right. Then there will be the statement of the defendant. Narration of video narration testimony. Defendant's recorded phone conversations. Limiting instruction relates to the firearms. Witness pretrial prep. Third party guilt. And defendant's election not to testify. Nobody has any issues with any of those areas, correct?
Not so far, Judge.
Okay. Mr. Murray and Ms. Massalone. Okay. Then we go into the criminal code. We discussed, I had indicated that the lesser included was the arson. I want to be clear that in this case, there's no lesser included to the murder. In this case, I've spoken to defense counsel in the past, and there was a discussion with Mr. Caneiro that there was no lesser included that were being requested. Is that correct?
That's correct.
Yeah, and for the record purposes, I would say there's nothing rationally based within this record to support anything other than whomever committed these offenses against the four victims. It's not an aggravated manslaughter. It's not a manslaughter. It would only fit the requirements of a murder. I don't find any evidence, any scintilla of evidence that there was any reckless behavior here. It was intentional, deliberate. So in that case, I wouldn't do it even over the defendant's objection. I agree. with the defendant and defense that does not exist.
Yeah, no, there's no
So
mitigating
after I
here.
read the murder charge, then I will explain murder by your own conduct. And then the verdict sheet instructions, as everyone will recall. I will give out the verdict sheet at that point. We'll need 16 verdict sheets for tomorrow. My law clerks who are seated to my left, they will give out, they'll have 2 packages of 8. They'll give one to the first row, one to the second row, and they can take one, pass it down. I'll then go over the instruction as it relates to each one. As it relates to the murder by your own conduct, and also the subsections afterwards of A, B, C, and D for Keith. Excuse me. B, C, and D for Keith, and then for Jesse and Sophia, there's also the additional question as it relates to age for both Jesse and Sophia. So that. Then I'll take the verdict sheets back so that they don't sit there and stare at it. Then we'll go to felony murder, count 5 and 6. Then aggravated arson in counts 7 and 8. After the aggravated arsons for counts 7 and 8, I'll then read the lesser included offense of arson, which again is the underlying charge for the felony murder.
Yeah.
Then it is possession of a firearm for unlawful purpose, which is count 9. So count 10, we'll go right to count 11. The verdict sheet that I have in front of me still includes a count 10, so count 10 needs to be taken out. I may have an old one sitting up here. So, yeah, so that shouldn't be in there. Oh, yeah. All right, this is an extra one. A lot of stuff going on up here. Let me just confirm. Yep.
Serially, 2 options of how to get down from the top of the chair. We're going to go right through the microphone.
Knife, which is count 11. And unlawful possession of the knife in count 12.
Stinkle, no.
Theft in count 13. As it was discussed with counsel, defense counsel had asked for the lesser included as it relates to the amount of theft that was taken. It's clear, though, in the charge on page 45, starting at the top, where it indicates that to find the defendant guilty of the offense, you must indicate whether you find the amount of money or value of the property involved. And it gives 4 different numbers: 75,000 or more, 5,000 but less than 75,000, between 200 and 500, and then less than 200. So they'll answer that question based upon whatever answer they give. That would be the degree of crime, if at all.
If at first you don't succeed, bother mom again. If she isn't giving you the pets, bother
Then
mom
there's count
again.
14, misapplication of entrusted property.
Don't do it. No.
Then hindering apprehension, counts 15 and 16. One deals with hindering the apprehension for the underlying crime of murder, and then hindering the apprehension of theft or the misapplication of entrusted property. 15 and 16. Then we get into, I give an instruction about deliberations, how it must be a unanimous verdict. I then give the verdict sheet back out, and we'll go over each one of the questions, and I'll remind them of that. I'll explain to them how they have any questions. If they have any questions, how they go about asking them. After that is done, I'll ask for a sidebar for the attorneys to see if I've missed anything. I'll then have, I'm going to ask for, Anna, that you'll need to look at whichever one applies. We'll have to swear in my sheriff's officer who will be at the door for deliberations. I'm also going to swear in a sheriff's officers who will be at the back door, so that I can say for the record that this entire room is secure. I will swear them in, and then at that point in time, I will pick my four alternates. We need to get the wooden box, and if you can put the 16 numbers into that, we can take care of that. I will then do that. 12 will go in the box, and they'll start their deliberations. Please, at the end of summations, I'll give you guys a break. But when summations are over, I'd like to have all the evidence collected. I want to put the evidence into the jury room so that it'll be seated there waiting for them. If I don't think that we're going to finish tomorrow where I've finished my charge, then we'll keep it out, and then we'll give it to them the next morning. Before deliberating, the four alternates will be brought back downstairs to 148. I may end up moving them because it's going to be difficult every time if we have a question or whatever it is. I got to bring them back upstairs. It's going to take a decent amount of time, so I may try to move them closer someplace. I got to figure that out. But as of right now, that's what they'll be in 148. Anybody have any objections, concerns, edits, issues that we need to discuss?
The state doesn't, Judge.
Okay. The defense?
Not at this time, Judge.
Okay. So with that being said, we will take the watermark off of the final charge. We will also mark, we will have to have marked for tomorrow 12 copies for all of the jurors so that they will be able to have them. I'll ask for us to make all 12 of them. We will also have to turn over a copy to each one of the attorneys. So if we can make at least 16 of them copies of it, that's what we're going to need. Verdict sheet will need 20 copies of the verdict sheet. So everyone has one they can look at. Make sure with 21 to include Mr. Caneiro so he has his copy of the verdict sheet. All right. Anything anyone needs to discuss before we conclude for today and we start tomorrow morning?
Yeah, Judge, we have a very detailed stipulation on a fancy piece of paper here for the court. Just Ms. Walsh looked at it and showed it to Mr. Murray and Ms. Castellone. I believe everyone's in agreement.
It says for the stipulation that would be added to under the stipulation section of the jury charge, it reads, Jesse Caneiro had an iPad. The parties agree that Jesse Caneiro's iPad was never seized or searched by police. Is that the agreement?
Yes, sir.
Is that the agreement, the defense?
Yes.
Okay. Do you want me to read that before we start summations, or do you want me to just do it as a part of the charge?
I would think part of the charge at this point would be sufficient.
That's fine.
Okay, we'll read it as part of the charge. If somebody, out of fairness, if somebody comments about that in their summation, I will not have a problem with that because I will address it within the actual formal charge.
Heather May, it does seem like they have done everything but the formal soliloquy. It might have been done during one of the times that we were skipping ahead. Again, I was not going to be kind to Katie, and I attempted to be kind to her today. So I will say that we might have missed that, but by all accounts, he will not he will not be taking the stand. So the defense ended on Paul's two daughters' testimony, and I don't think either of them did a great job illustrating anything other than the, I am sure, traumatic amount of processing they are going to have to do to come to some sort of any level of peace about this.
Let everyone know that. All right. Anything else that we need to discuss?
Can we just have one
Do we
moment?
have a minute to confirm with the state?
Sure.
Can we go all the way to the moment?
Again, sir, what exactly is your purpose? You have done BF nothing. Like their interns are walking around always getting boxes, always picking things up, putting them down. This man has done, again, BF nothing.
Bill is outside the courtroom. Right there. The wheel has been brought through the hallway.
Oh, nice. It's exciting. Do you guys know what you need to add and where? That's hurtful.
Okay. This woman hurts my heart. We're going to go back just a minute because look, ma'am, as a person who thinks you have a cute little figure under this, your hair is a terrible style. It's all one length. It drags your face down. You do have a rounder face. So I get what you're trying to do with having longer hair. The problem is it's still a fat face with long hair. Now, believe me, I have had stylists tell me, like, no, you can totally hide a fat face. No, you are, look, people, it's not magic, it's hair, okay? And if you wanted to keep the length, adding a bit of layers, having a couple front facing, kind of face framing pieces, I think would do wonders, and then add some dimensionality. Because whatever you have, look, whoever told you that headbands, those big puffy headbands were a good idea is lying to you. Because I dig your shoes, I dig your entire outfit. That hair needs Jesus, ma'am.
That's hurtful.
It's on the record, so.
I'm not arguing with you.
No, it's not that. I know it's the type of hairstyle I would have had if I was self-conscious, and the problem is that you're not accentuating the positive things, and what you think you're doing with your longer hair isn't quite, it's really hiding. She has a pretty face. When they've showed her up close, she has incredibly clear complexion. It doesn't look like she's wearing a ton of makeup. So she's already so much more authentic and pretty than so many of these e-thoughts. But she's just, a couple tweaks, and I think she would feel so much more confident about herself. But maybe she likes the way she looks and she loves the headbands. If so, rock on with the headbands.
Okay. All right, thank you all. Everybody have a good night. I'll see everybody tomorrow morning. Start at 8:30.
Okay, so I think what we're going to do tomorrow is that we will start at 10 just because we're going to have all the jury instructions, all the charging documents, and I know myself, I might want to fast forward through those things, and I'm assuming you guys will probably want to do that too. Uh, and while it was okay for today, the judge was kind of insinuating that we might not even get through the ending of the charging documents today or tomorrow fully, uh, unless that was a misquote. So we are going to be starting at 10. So we're not going to do the 30. And then tomorrow is Wednesday. So hopefully we can get a good chunk of the morning done before I have to take a break at 2 and then be back here at 3:30. So that is kind of the plan. We will have mornings with Mo, and it is your last chance to vote on Cosplay Wednesday. Now, it looks like Miss Frizzle's gin drinking sister, is winning in the polls. But if you want to play your part for democracy and whatever I wear to confuse my son's my son's private school as I pick them up, put your votes in. I cannot for the life of me remember the other two options, but they're there. So, past me remembered them. And thank you so much for hanging out. I will be cutting up the videos of the sort of grab your popcorn issues going down from this morning. And then probably also the other daughter's testimony. That being said, I don't know what the defense thought they were going to achieve. I don't know what's going on. And I think that the state not calling Corey was a very, very kind thing for someone who has had to defend himself from, frankly, the judge called a spade a spade. Not in the realm of reality allegations. So I'm glad that Corey didn't have to testify, but I'm imagining that should Paul be adjudicated guilty, the victim impact statements from him are going to be, should he give one or have one read in, are going to be doubly heartbreaking for not only the loss that he has with Keith and his family, but also the betrayal of his brother using him as a shield, as a third party third party culprit. So I think that will be interesting. It will be interesting to see how the other state attorney, Mr. Pacer, will deliver the closing. I very much liked the opening from the state. She didn't use notes. And I do like, there is a level of professionalism and preparedness and kind of comfort with the subject matter when you can see a lawyer do a closing or an opening with, glances at their notes, but they sort of have it down pat. And I feel like we are going to get a pretty good closing with the state, regardless that I anticipated it being the female attorney closing. And at least we're going to get something roastable from the defense. So that's kind of the plan for tomorrow. Thank you so much for joining. And remember to share this out with those among us who have dark sense of humor, enjoy snark, and are attempting to be a more hydrated and kind person. But, you're allergic to stupid and they haven't invented an EpiPen yet. Pfizer, get on that. So have a great day. Thank you all for joining me. And you are free to go wherever in the interwebs you want to go. Not that I'm trying to get rid of y'all really quick, but I am about 12 shades of done with being in the wig. So, so I am going to do a quick exit. Thank you guys so much. And we will see you tomorrow for more of this train wreck. Bye, you guys.